If you haven't seen James Cameron's hit film Avatar, you've probably been hiding under a rock, but not one of the rocks from the floating Hallelujah Mountains.
Yes! The legendary floating mountains of Pandora? Heard of them?
That sparked so much controversy when fantasy artist Roger Dean filed a copyright suit against Cameron.
James Cameron's being sued for the 4th time. Fans praised James Cameron for his spectacular idea that we call Avatar. But it turns out that he may have stolen it all from someone else. Artist William Roger Dean filed a 17-page complaint.
Dean accused Cameron of directly copying 14 of his paintings and filed a $50 million suit against the director. Not too shockingly, Cameron and his big money lawyers won the case.
Oh my God.
The theory that came into question when the copyright law was discussed was mainly the idea-expression dichotomy of the work. You see, you can copyright a specific work, but you can't copyright an idea.
It wouldn't be infringement unless the exact graphical composition was the same. Unless it is, I have a rock here, here, and here, and I have a rock here, here, and here. If it's I have a rock here, here, and here, and I have a rock here, here, and here, yeah, well, what are you copying? That's just inspiration.
I think that copyright claims have to be fairly specific, so that's maybe why they settled on the floating island. It's not just the sort of look or the color scheme, it's that specific thing. And that's how you go after someone for copyright. But if he wants to do it on the basis of this idea of the gravity-free island, that certainly has been seen in both visual and literary art going back much longer than Roger Dean's career.
While Dean does have a claim to his artwork and his expression of the idea of floating mountains, it's hard to argue that somebody could have a copyright on the idea itself of floating mountains. Many legal concepts of copyright were used in the resolution of the case, though whether or not these were applied fairly is not entirely clear. At the most basic level, it is crucial to note that copyright protects the expression of an idea, but not the idea itself. Further, expressions of ideas in the public domain, such as flora and fauna and nature, cannot be protected. When examining a copyright claim, only the protectable elements of the work in question can be evaluated for similarity. Thus, ideas such as floating mountains, dragons, and waterfalls were dismissed as common fantasy manipulations of nature. However, there was little to no acknowledgement of the similarities when works were examined holistically. The precedent of examining copyright claims for total concept and feel was brushed aside, and similarities in composition and tone were nullified by differences in small detail.
A lot of these pictures, like these 4 that you showed me, the composition is almost exactly the same. Like the positioning of the warrior and the creature is in the same exact position, with the warriors and the other warriors in the back. And then in the mountains one, the mountains are basically positioned in the same exact spots. And the morning dragon, although the dragons are in different positions technically, it's still, the composition of the picture is still dragon to the right where mountains are to the left. And then for the arches one, this one is also a bit different, but still very similar in the sense that the arches are both in the center, and they're continuing back. Even the time of day of these different paintings looks like it's the same, with the amount of sunlight and light that's coming in.
An apparent dissimilarity in boulder sizes and a lack of photorealistic vegetation and background disqualified Stairway to Heaven, and the similarities of many rock arches were overlooked due to differences in texture and style. The biggest factor considered in attempting to prove the copyright was the mise-en-scene of the film.
Mise-en-scène is a French term. It's actually a French theatrical term. It doesn't have an easy English translation. It literally means putting into the scene or putting in the scene, and it referred in theater to essentially anything that would be put onto the stage, which would include light, but would also include obvious things like costuming, makeup, set design, props, and staging and blocking, the arrangement and movement of characters on the frame of the proscenium stage. In film, it means all those things as well. That all the things that are put into either the frame, as in the film frame, or that are put into the scene that's represented by the narrative, that all counts as mise en scène.
It is noted that Avatar, as a motion picture, is comprised of rapidly changing frames, camera angles, and lighting, and to remove a single, static frame fails to account for such dynamic characteristics. As such, it is necessary to evaluate how single frames of a film are incorporated into the whole, and to what extent they stand on their own. Do you think that it's unfair to compare a static image to a screenshot of something that's normally a moving picture that has a plot and changes in camera angles and lighting and such? Is it unfair to only take a still scene from that?
I don't think so, because ultimately this picture from the video is the exact same as this still picture. There might be more added to it, but if you could find an exact frame that looks exactly like this image, I think that that's unfair to the painter, to Dean, to have his exact image put into, part of a clip of a movie.
The Scenes of Fair doctrine specifically states that copyright protection does not apply where a sequence of events naturally progresses from an inherent choice of concept or situation, and it is likely that the still frames of Avatar in question are a result of choices in plot and setting. One of the deciding factors for the court was whether or not a lay observer would consider the works as a whole substantially similar to one another. We decided to ask some people on the street, lay observers, whether or not they thought that the works were similar enough to warrant a copyright claim.
Well, it's interesting because it's a question in a sense too of appropriation, and anything can be appropriated and used, and where does originality come from? Is anyone original? It's just interesting to me that they're so similar, the imagery.
Yeah, he definitely copied the artist.
If this is a poster, then we got an issue. If this is one of the pictures you're talking about, then I certainly see why this guy is not. That seems suspicious, to say the least. I mean, because that, I don't know, where I come from, we do have natural arcs, but they don't look anything like that in reality. And having just the style of it, the protected center, that...
Yeah, I mean, I'd agree that it could be hard to prove, but I think the thing is that since there's so many examples of the same type of thing with the same artist in the same movie, then yeah, it's kind of implicative.
Yeah, they look very similar to me. They both have a horse-like figure that's it's in the same position, so they look very similar.
I think James Cameron done fucked up.
Oh, look at the adorable copyright infringement.
I understand why it's hard to prove, because I think sometimes people take inspiration, especially even from not Renaissance, Expressionism painting. I feel like a lot of people have taken inspiration from those sometimes.
Even though they're just a similar idea, I mean, this one looks like they're both floating, but that one kind of looks more like a rock, and that looks like dirt. So, I mean, maybe they should have given him credit, but I just don't think there's enough evidence for that to be a real lawsuit.
Because that I wouldn't call infringement of any kind. It's a person riding a quadruped through a foresty area. I don't know, that's like saying, hey, we both used a rectangle.
According to the copyright case document, a work is less likely to be considered copyright if a layperson cannot confuse the original work for the allegedly infringing version. Classical philosophy actually has many interesting ideas about copyright. Locke's ideas of ownership by labor applied to Dean's artwork, in that since Dean expended the effort to create the paintings, both physically and mentally, the resulting paintings and the formation of them is his. However, according to Hegel, the personality attached to the object allows for ownership. Here as well, it would seem that Dean is the owner of his vision to paint something, since he put his effort into it, his creativity into it, and therefore it's attached to him. However, Cameron also would have some claim to the film Avatar and the inherent scenery. Utilitarianism seeks the most good for the most people. In a broader context, the most good would come from people having ownership of the things they create, and through this view, Dean owns the paintings. Indisputably, Dean owns the physical paintings as an expression of his work, but the question is, at what point does the expression become an idea that can be copyrighted? In contrast, Marxism could be used to argue that Dean was merely an artisan who was attempting to support himself. Cameron, in this case, would be the figurative factory owner who attempted to infringe on the rights of the individual in order to draw a larger profit. Through a Marxist lens, Cameron should not have been allowed to use the work of Dean in such a way. It doesn't seem that we can conclusively say that the two works either could be considered dissimilar or similar. However, it ends up being immaterial in that the court's decision prevails at the end of the day. The Dean is responsible for showing the court that Cameron likely used his images, and has to move the court from thinking that Cameron could have used his images to thinking that he probably did. This follows from the innocent until proven guilty principle, whereas Cameron need not prove his own innocence, but Dean needs to prove his guilt. Dean could not prove that Cameron had seen his works, and therefore could not definitively show that his images had influenced the design of Avatar.
Sorry, Roger Dean.